Start. The petitioner contends that the tribunal has committed an error by allowing the claim petition in view of the fact that the claim of the respondent number 2 had already been rejected as he himself had voluntarily refused to take up the job of a sweeper and therefore the respondent number 2 cannot claim compassionate appointment as a matter of right. Stop. It is further submitted that several reasons have been given while passing the order that the vacancies were not available within the 5% quota and the appointment on compassionate ground is not a matter of right, and further respondent number 2 and his family was financially well off so as to provide enough aid, and hence compassionate appointment was not permissible in view of the guidelines framed by the government policy. Stop. Another reason given is that the claim is on account of death of respondent number 2 and therefore the compassionate compassion did not exist so as to give rise to any claim. Stop. Para. Sri I.P. Srivastava submits that the answering respondent was prepared even to perform the job of a sweeper and the appointment of the answering respondent was cancelled void order dated 14th November, 1998, which is bereft of any reasons. Stop. He further submits that so far as the subsequent order dated 4th July, 2002 is concerned, the same reflects non-application of mind, in as much as, it does not even refer to the earlier offer of compassionate appointment made by the respondents, and further none of the aforesaid contingencies are available for denying compassionate appointment as has been indicated therein. Stop. He further submits that the answering respondent is even now prepared to accept the job of a sweeper and his claim survives, in as much as he had approached the authority well within time. Stop. Para. Having heard learned counsel for the parties, it is evident that the claim for compassionate appointment was made immediately after the death of the father of the answering respondent. Stop. The said claim was processed and the appointment was offered to the respondent. Stop. It appears that another application had been moved by the answering respondent on 22nd May, 1998, which was also pending consideration for being appointed as a Mazdoor. Stop. The answering respondent appears to have been made a request to the authorities that he would be unable to perform the job of a sweeper due to fear of a social boycott, and therefore he may be offered the job of a Mazdoor. Stop. The cancellation order of 14th November, 1998 appears to have been made only after such request had been made. Stop. The said cancellation order, coupled with the subsequent rejection on 4th July, 2002, were challenged by means of an application before the tribunal, and the tribunal, after considering the submissions raised, allowed the claim of the petitioner, questioning the aforesaid two orders, and the authority was directed to reconsider the applicant for appointment on the post of Mazdoor, and in the interregnum period was also directed to allow the respondent to continue as Safai Wala. Stop. Para. To our mind, in view of the facts as disclosed, the tribunal could not have directed for a reconsideration of the appointment of the respondent on the post of Mazdoor, as there is no second choice available in the matters of compassionate appointment as held by the apex court in the case of State of Rajasthan versus Umrao Singh, 1994, 6 SCC 560 stop. A perusal of a application moved by the respondent subsequently on 24/9/1998 does not indicate that the respondent had surrendered his right to receive compassionate appointment and had made a request to the authority to change his status on account of a fear of social stigma being attached on working as Safai Wala stop. The respondent never wanted to surrender his right of employment and wanted to a resolution of the aforesaid comprehension in his mind stop. The same was taken to be denial by the respondent to receive compassionate appointment and accordingly it was cancelled on 14 November 1998 stop.